a small plug for Pokey Lafarge and something in the water. But it has been this year, it seems like, quite a spate of very large employment verdicts. And we're going to talk about the cases so that maybe we can learn something about what happens to go through them. So we've got, of course, two cases from the athletic department at the University of Iowa. We've got the Iowa Senate staffer who was fired and had her verdict this summer. We had a somewhat less well-known and less reported Grinnell Hospital employee who was fired, has a big verdict. And we had the Supreme Court decision, that was an earlier trial this summer, on an ethanol case in, I think it was Worth County, just south of the Minnesota border. And all of those tell us something. And then we've got an older all-time UPS record case for a verdict to visit about. And so we're going to talk about what they are, what happened, what do they have in common, and what can we figure out about all of it. So first of all, I want to say, when I talk about these cases, I'm not an insider on any of them. I have a little bit of information that relates to one from John Landon of our office, but otherwise, it doesn't. I'm trying to analyze these situations. I'm not criticizing. I may be willing to criticize with alcohol, but I'm not criticizing. And I want you to understand that when anybody goes through a trial, you make a lot of immediate decisions. It's kind of like being a race car driver, very hard to on the fly, and sometimes decisions are made that may not turn out right, but you just have no choice to make one. Now, first of all, I think you need to understand what is a trial and what is it not. It isn't a search for or a determination of the truth. At best, it's what looks most likely to have happened. And all of that is based on tons of information combined to try to create some narrative. And each side should always have a narrative. And the narrative should always be sold from the first moment that the lawyer stands up in front of that jury, or even before. Trials are done pursuant to very weird evidentiary rules. Very few of us understand the infield fly rule. Very few of us now can figure out when a catch in the NFL is actually a catch or what a football move means. Who remembers Ferris Bueller? If you paid any attention, and perhaps you didn't, they spent some time in the Art Institute. And there's a wonderful scene that involves Mr. Seurat's painting. Now, am I here to tell you that some sort of 19th century Parisian leisure painting is the point of what we're talking about? No, what I'm trying to do is communicate to you, and this is what happens when you're married to an art teacher, that this painting is done by a pointillist, which is really somewhat of a misnomer. He's really a dabbleist. And so, if you remember from Ferris Bueller, there's an extreme close-up where you see one dab of paint that turns out to be on that lady's face. And my point is to tell you that in trials, that's very much similar to what we're talking about. There's a million dabs of paint, and each individual dab is usually not very controversial. It's how those dabs of paint relate to each of the other dabs of paint that then produces something that looks like a painting. And you have to kind of keep that amount. You also have to keep in mind that in these regards, and I'm going to plug a great legal movie, Absence of Malice from 1981, Paul Newman and Sally Field, where they talk about, is it the truth? No, but it's accurate. So there's a ton of accurate information that can be stacked in one place in a particular manner, as with the dabs of paint, to try to represent truth, and it may not. Guess what, people? There are plaintiffs out there who've won big jury verdicts who may not have been the best employees and may not have really been doing their job very well. But at the end of the day, they had a narrative that sold better. And I'm not saying they didn't. I'm just saying I know those are out there. I've been in some of those cases. That narrative sold better than the countervailing narrative, and the jurors decided the case. And that's what it's about. Whose narrative wins? Okay, so first, Kristen Anderson, I think her name's Kristen, worked for the Iowa Senate on the GOP side, filed claims for sexual harassment, sex discrimination, and retaliation. And she was fired 7 hours after reporting a discrimination complaint. Oh, that's a terrible fact. Sure, it's a terrible fact. It's also true that sometimes people hear the train's coming and they run to try to get to the station before the train does. So I'm not here to express an opinion about her behavior. What I will, or her performance, what I will tell you is that undeniably she was subjected to some bad behavior by a guy who stayed in his position until the end of this story. So her coworkers supported her claims, male and female, that this fellow had, and others, had misbehaved. There was an Iowa senator who had also misbehaved. He was, I think, no longer in the Senate by the time of trial. And at the end, of course, she got $2.2 million, $1.4 million for past emotional distress, and $800 for future emotional distress. That does not include what would be hundreds and hundreds, and I'm guessing $700,000 or so for attorney's fees for that case. Now, what happened after that? Well, finally, 3 weeks after the newspapers reported the verdict, the bad actor was terminated. Other coworkers came forward, or maybe they would testify at trial, but publicly talked. Senator Dix dug in, always a good sign when you're in a hole, dig, 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 and said poor performance and no other reason, and decided not to release the results of the investigation that was done as a result of the lawsuit and its result. And he will not share, this week's news was, he won't share an HR manager with the House, which, by the way, has a female speaker. They settled the case for $1.7 million. I guess $7. I guess maybe I knew that subliminally. They settled the case for $1.75 million, and of that, $700,000 went for the lawyers. Haskinoff, this is the one that was just decided on appeal. An ethanol plant. Now, first of all, you can kind of tell from the backgrounds of what are we talking, what's the situation. Well, an ethanol plant, you've probably got a pretty good idea in mind of what kind of workplace it is. Similarly, you probably got a pretty good idea of what working in the Senate would be like. Rough and tumble politics. I'm not going to take anything from anybody. Hit me, I'll hit you back. I don't care if you're a Gold Star mom or not. You know, that kind of behavior, toughness in both places. Now, there's two specific incidents, and this is a company that really did nothing wrong as a company. In all of these cases, folks, everybody had the policies they were supposed to have, okay? There isn't anybody who just didn't have the policy. Well, we got a policy, we're good. All of them did. In this situation, the operations manager was the bad actor, and he talked about them puppies, or that instead of paying for a mammogram, perhaps she could just go out into the parking lot and other employees would pay to examine her. It got hot. He got worried after she reported it, came to her saying, I don't want to be fired, I don't want to be fired. She said, okay, I don't want him to be fired. The only mistake the company made then was taking her word for it. And I would say that's a big lesson. You get information, you act on the information, you make no promises when somebody makes a complaint, you do what you should do. Sometimes you don't hang the person that they want to be hanged. Sometimes you do hang the person they don't want to be hanged. And you just have to make, that's a mistake. They didn't fire him. Because she had kind of misbehaved in the way she reported it, they even disciplined her for that. And then a bunch of time passes, but one of the things that happens is he gets a promotion. And now he's the boss man. And he makes a comment that she overhears that she was getting married for money. And she blows a gasket, and she calls him nasty names, and then she apologizes for it. And again, the company comes in with an immediate investigation, and then she reports a bunch of stuff, screensavers and inappropriate conduct and that kind of stuff, all kind of lowish level stuff. And then he wants to discipline her for having left the afternoon, that she overheard him and she was upset, and then he looks deeper into her behavior and her conduct. And the lawyer who's investigating it and the HR manager saying, let's just take it easy. And he writes up two versions, one of which was overtly critical of her in a manner related to what she complained about, and the second of which had no reference to that. He said he liked that one better because it doesn't look like retaliation. Now, she sticks around for 2 days, and after a multi-week trial, $2.5 million total, of which $850,000 was for 8 lawyers and 1,700 hours on this case. The judge gave her and them every penny they asked for. Now, it went on appeal. It ultimately got reversed. There were some errors of law. It's an opinion about that thick. Hawkins case, a gentleman who worked at Grinnell Hospital for 40 years. He was the lab director. Now, there's a lot of Peter principle in the world, folks. People get into jobs they shouldn't have, and they stay there for a while. Nobody pays attention, whatever. I'm not justifying it. I don't know anything about his performance. Ultimately, this guy had breast cancer, and as happens in a lot of situations, a new employer, this hospital had money problems and they were going through management changes. A new supervisor came in. He felt targeted. He was replaced. Ultimately, he was 63. He's a pup. He's just a pup, and they fired him at 63. And he was replaced by somebody who was 53. A mere youngster. He got $4.5 million before lawyers. Now, this is going to be set aside, or it'll be settled, or it'll be reduced. I'm not here to tell you that you get to keep that kind of money. I'm not here to tell you that they can decide that somebody had $2 million of past emotional distress with a lot of evidence and all that kind of stuff. What we're here is talking about what pisses the jury off so much that they would do it, okay? Is it going to hold up? That's not really the issue. $2.25 million for future emotional distress damages and $2 million for past emotional distress damages. And you can see it. Conversely, the lack of money was only $220,000 in terms of how the jury looked at things. Again, before you get to lawyers, again, in your mind, be thinking south, but maybe not that far south of $1 million for lawyers. Now the university cases. I'm going to talk first about Griesbaum because it really is what you need to know to understand these two cases. And Tracy Griesbaum was the University of Iowa field hockey coach. And she was terminated and then filed a claim for gender discrimination, sexual orientation, she's a lesbian, and retaliation claims. And the retaliation claims really relate to what was done to her partner, Jane Meyer, who may be a little bit more familiar to you. She was a 14-year head coach at the university. She had 4 conference championships, 6 NCAA tournaments, and was in the Final Four. And field hockey is the one where they carry those neat clubs, you know, and they weren't kind of like the Catholic girl skirts when they're playing. Anonymous report of a parent that there had been player mistreatment. And that started the whole thing that was then investigated. This is under the BARDA regime. Bowlesby is gone. And in fact, they make Bowlesby the hero of the case in a way, just part because it makes BARDA look worse, I think. They did an investigation. They found that there were no university rules violated, but she was guilty of bullying her players and intimidating her players. And they fired her, but not before she made a complaint that what was going on is that they were refusing to investigate the fact that this whole thing stemmed from the fact that she's a lesbian. Kind of a nasty brew if you think about it in terms of lawsuit terms. Now, Griesbaum was the Griesbaum case. We're going to hold on. Griesbaum, she alleged the demotion of Jane Meyer, as I said. And then the case really went through some incredibly difficult, head-scratching, emotional, philosophical issues that really relate to men and women in society and specifically in sports. And I would commend to anybody, because it's just beautifully written. I tend to call them press release complaints. The petition that Griesbaum's lawyers, and the same lawyers as for her partner Jane Meyer, filed in this case, the lawsuit, where they take it all, and this is historically accurate. University of Iowa used to have a women's athletic director, Dr. Christine Grant. She was really famous, well-known, honored, respected, wonderful person. She retired, and then they merged the athletic departments so that they only had one. And there was supposed to initially be a women's head that went under that, and then that got restructured and all those sorts of things. They traced through the history of female coaches at the University of Iowa in the last years, and a bunch of them failed. A bunch of them were accused of having failed, and they made a wonderful presentation, I don't know if it's accurate or complete, about how that compares with others, men who were failing in terms of team, how related to support for the programs, resources, all of those sorts of things. And then talked quite persuasively, in my opinion, and it's a hard issue to figure out, about everybody's knowledge that, at least in the basketball program, you don't even have to be in the building to hear the cursing. Now, I think there may be less in terms of the head guy on the football program, but at least in basketball, that's obvious. If you can read lips, you can see it on television. It's apparent. It's also apparent, frankly, that maybe that style has an effect on young men that it would not have on young women. There's also a comparison of men coaching female sports and as opposed to men coaching male sports, and as opposed to females coaching female sports, and how those people had greater support from the university and resources and those sorts of things. I think money talks. And obviously where the money flows indicates something. And of course, as I said, they talk about Bowlesby and basically say that Gary Barta came in to undermine women. He may or may not have, I don't know. The case wasn't tried because of Meyer. And I think the Meyer case was tried because the university considered itself to have had a better case. That's my guess, don't know. But Griesbaum was fired first. Or Griesbaum was fired before and started kind of the whole thing. She was really, really mad that her partner had gotten fired, and she spoke inappropriately, in quotes, because I'm not sure how inappropriate it was under the circumstances, at Barta. And so there was testimony in her case about that. She blew a gasket. Barta decided to move her. Now, I will say that relationship cases can be difficult. We've been through that before with clients where we've said, okay, you're firing one spouse and the other one still works here. What do you do? Well, I'll tell you what you do. You go to the first one, you say, the one who's not getting fired, and you say, look, we consider you a valued employee. we're not asking you not to be mad at us. We're not telling you your feelings are not appropriate or valid. We are saying to you, however, that you should take some time to think about it. And after we made that decision, and we understand you're going to be mad for a while and you may act up a little bit, whatever, but at that point, you're going to be held to the same standard as everybody else. And you've got to decide, you still feel comfortable working here, or would you prefer not to work here, or how are we going to approach the whole thing? And you can do much to diffuse all of that. None of it appears to have been done in this case. They moved her to a job supervising construction at the University of Iowa, of which there always seemed to be plenty, except ultimately that ran out. She filed a lawsuit, Griesbaum filed a lawsuit too. Meyer's claims in the case were gender discrimination, sexual orientation, because I was a lesbian, retaliation, because she then complained and then she filed a complaint. It's a little harder to understand, frankly, because of the way the facts were, and a whistleblower claim. And also unequal pay because her replacement got more money, and then she said, and that was on purpose. That's another thing that's very troublesome, and it shows up a lot in cases brought by women, and that is in systems that don't have structured pay, there's frequently issues that can be there, and the allegations are simple and the disproving is hard as to whether or not it's discrimination or not. They tend to have value, those claims. And it was said it was willful, which then means that you would double a piece of it. Okay, so what's the defense say through trial? Well, she didn't do her job well. She got mad at BARDA. I'm sorry, I think you fire my wife, I've got at least a day to get angry about it. You know, I think that's fair. Maybe a week is long enough, but I've got at least a day. And BARDA didn't handle that very well. And then the other thing they did was they brought in the big names to say they didn't like working with Jane Meyer. And I would tell you, and I've told my physician clients, that one nurse as a witness is equal to 2 and sometimes 3 doctors. But they brought in the big guns. And so Ferentz talked about whether or not a brochure met his standards. Jurors laughed at that, by the way, reported afterwards that was laughable. There was an issue about the jacuzzi in the football program. I know somebody who's the uncle of one of the lawyers for the plaintiff. The cross-examination on that point went something like this. Now, Coach Ferentz, you said that she didn't get the jacuzzi fixed. Is that right? Yes. Whose jacuzzi was it? Was it the player's jacuzzi? Oh, no, the coach's jacuzzi. And the newspaper reports that you made $4 million last year? Did it not occur to you that maybe you could fix the jacuzzi? Now, I'm not saying Kurt Ferentz should pay for the jacuzzi. I'm saying you can see how that goes when you bring in people at a high level to support your claim, when I understand that there was, and similarly, Tom Brands, who is wonderful in terms of his public presentation. He just looks like the Tasmanian devil at all times, you know, he's so jazzed. And it was a leaky shower or something. Now, apparently, there were all kinds of minor sports coaches and athletes who would have been available to say things about Jane Meyer and the way she treated other people and the way that she did her job. That was never in the paper. No, we relied on the names everybody would know, because obviously Tom Brands and Kurt Ferentz have the kind of credibility that no peon or no coach of some piddly sport would have. And again, I'm not trying to comment on the facts of the case because I don't know the details of what did or didn't happen. She won everything, $1.5 million almost. Part of it will be subject to doubling by the judge, and the lawyers had not yet submitted their claims. Now, they settled both of these cases for a total of $6.5 million. Same law firm involved. It's got like 3 people in it, folks. The lawyers got $2.6 million. Their clients got 3.8. And there's a stray $100,000 in there that I took. Okay, now the whopper of all of them is this Channon case. It was in 1998. It seems like a long time ago. How can Zeiger say there's something in the water? Just a minute, hold tight. No job descriptions, no posting of vacancies. This is UPS for people, and I'll guarantee you, I will guarantee you that this is no longer true of that company. No salary ranges that were published, and advancement wasn't based upon applications. It was based on supervisors keeping mental lists of who might be good to promote. Now, Ms. Channon was on those mental lists, all of them, and she was doing great. Best ever production, promotions, transfers, more responsibilities. She's climbing that ladder. And then she got in a position, box line, I don't know what the heck that means, where a union employee accosted her, got mad about something, and it was a physical confrontation where he was bumping her with his chest. She was backed up against equipment. He poked her in the chest. He trapped her. He was out of control angry, just really out of control angry. Now, they did a good job. They fired him. But he had apologized to her. Ultimately, the process with the grievance procedure, because of the apology, they said he could come back to work, but he wouldn't get any back pay. And he was reinstated about Thanksgiving, and he wasn't ordered to stay away from her. Now, you're going to see these occasions like when they didn't fire the guy because she said, I don't want him fired. Everybody say, well, wait a minute, we could have avoided all of that. And they don't. So he didn't get fired. He became a union steward, which made it worse after that. She got counseling. He and his buddies stalked her and intimidated her, blocked the doorway, scared the hell out of her. By January, there's a change in the order, and new bosses come in. Familiar, several layers, one which was familiar with the other stuff. And almost immediately, the performance problems of this former star happened, and they continued, and the stalking and the harassment continues. And then they give her a 60-day thing. They didn't allow her to try to explain, and the guy who gave her the discipline mocked her and said, oh, help me, help me, help me, and when she was trying to explain some of the circumstances. They told her she had to go on a vacation, which she did. They changed the process, and when she came back, they said, now you follow the orders of your peers instead of you having your own authority. The guy that did that stuff had misinformed his boss, so his boss, who had to approve all of this stuff, didn't know that there was the assault and the stalking and the failure to respond to complaints. And she gets a lawyer, they learn about it, and immediately this process escalates even more. They transferred to a new area where she was likely to fail. And they came in with buyout plan to flatten management, save money, and the women took it, except for her. They then got to more of this stuff happened. She gets to the point where she leaves for medical reasons. The lawsuit, other people kind of challenge her for the lawsuit before she leaves, telling them they're mad about it, they're sick about it. She's got these ongoing problems, has a diagnosis of PTSD. Now, I can tell you, not everybody in the universe who can get somebody to say they have PTSD actually has it. I've had a case where I don't believe that was the situation. I'm not saying she didn't. She's out on medical leave, and she stays on medical leave. She sues for sex harassment, discrimination, pay differential, and retaliation. 5-week trial. What do we get? Yeah, that's right. Now, who knows David Muir? He's the anchor guy on ABC, right? When this verdict came out, it was about 4:45 in the morning. David Muir was still doing the overnight news. When I saw that $80 million verdict, it happened the day before, and my first news of it before it was in the register was from David Muir, and he was about 14. So you see the numbers. It goes on appeal. They take, the bottom line on all of that is, that there's a $300,000 cap on punitive damages. There's a federal $300,000 cap on the compensatory, and there's liquidated pay. So she ended up with that. Now the attorney's fees would be separate. The attorney's fees would also include the appeal and all of those other things. So that number probably, even in $1990 or $2,000, would probably be $1.5 million, I'm guessing. So what are we talking about? Well, part of it, I think, is political. And by that I mean Americans have always rooted for the underdog. But there's a whole lot more disillusionment now. There's a whole lot more of people believing that the system works against us, that the people in charge always win, and that they don't do anything to take care of us. And that anger kind of percolates through all of these cases. Now, I could have brought over a bunch of cases where the defendant won. That's still a lot of it. And that's certainly current. What about Shannon? Well, I looked up what was happening at the time, and we're in the middle of the Monica Lewinsky scandal and just a little bit before the impeachment later. So that same stuff was going on in terms of anger at the system. They're not helping me. They're not helping us. Now, think in terms of process. The company that did everything right was the ethanol company. But they had a rogue guy who wanted to discipline a woman who had complained about him and almost got him fired, right? They were in the middle of an immediate investigation, had the right lawyers involved, they were doing what they were supposed to be doing. They tried to talk him out of discipline, and he wouldn't be talked out of it. Retaliation is a huge issue in all of these cases because people get personally mad after they've been accused of doing something, and they make it worse. I'm here to tell you I believe that Roy Moore probably made it worse. I think Louis C.K. probably made it better. Maybe Al Franken made it better. You just have to understand that authoritarian displays are not the way to go. And I could point to the Channon case specifically, but also the athletic department cases and all of these, that people who are in charge. You mean to tell me I can't make this decision? And they ask a question when they call on the phone, and the answer is, well, yeah, you can do that. But you're talking about one dab of paint. And I'm trying to talk to you about the whole picture. You have to understand that. Age is always a problem. When you've got changes in regime, when new people come in, I'm not saying that something that was unacceptable wasn't tolerated for years and should stop. I'm saying you have to go through the process in a way so that you can help insulate the employer from protection. And the answer isn't to call the lawyer after the civil rights charge has been filed. Okay? It just isn't. It just isn't. By then, it's too late, frequently. The emails are what the emails are. And then you've got subjective decisions. This is really kind of a process thing, but think back to the Channon case. People making subjective decisions. I'm not saying that those supervisors were wrong to have the people in mind for promotion at any given time that they had. I'm saying that somebody who merited promotion for a long time and that wasn't recorded in a manner that kept her for future promotion is a problem because it disappeared once you get new people who don't remember, and it becomes a what have you done for me lately that's very hard to deal with in a trial where jurors will find out what the whole thing is, where people have been denied the opportunity to have opinions. Those employees suddenly are presenting their side, and that's what they're listening to. Long trials kill employers. I can't imagine being in a 5-week employment case and not end up reporting a plaintiff's verdict. It's very hard for me to picture that sort of thing. And you've got the documentation issues. It's both a sword and it's both a problem and a benefit. You have to write it down. But guess what? If you're going to do 2 versions and then say the second one doesn't look like retaliation, you've got some big issues. Because, of course, the other version doesn't disappear. The interweb holds it someplace. It's in the cloud or something. I don't know. And then you've got these relationship issues that relate to retaliation primarily. So what's the point? Well, I think the point is to give employees those choices that you can give to employees. Well, wait a minute, I own the company. Right? Do you want them to stay? Do you want them all to be pointing in the same direction? Do you want them all rowing together? Or do you not care? It is your choice. Do you want to risk these sorts of cases when people aren't treated with respect, whether it's the athletic director at the university or a college president or ethanol plant manager? It will come out. It's a big wheel. There's a lawyer in Iowa who used to say it's a big wheel that doesn't go around more than once. And it's just bad karma, frankly. It's just not good. You want to think about the rules you learned in kindergarten. You want to think about the golden rule. And then you have to understand, as I said, that there's lots of places to get off this bus. Lots of places. Every single one of those cases, frequently because of testosterone, could have gone away at any earlier point and didn't. Didn't have to happen in the first place, could have been acknowledged sooner, could have been dealt with. I actually had a client stand up in front of a group about this many employees and say, I want to apologize to these two people. We unfairly singled them out. We terminated them for something they didn't do, and I want to apologize. And I'm the one who had to go into that office and tell that CEO to do that. Didn't stop the lawsuit, but it took a hell of a lot of zeros off the end of it. And that's the way you have to think about it, because it's harder for governments because of accountability issues. And as I said, think about holes and think about getting out of them, not expanding them. Thanks.